Big news for Will Smith. A judge basically just threw out all of these claims and a lot of allegations that he was facing in a sexual harassment lawsuit. But I will tell you, you may not want to roll the credits on this one just yet, because this may not actually be over. The judge who ruled did something else, something that could maybe bring this case back to light. We have the ruling, we're going to do a legal breakdown, and we're going to talk about it right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, big news, huge news in the case against actor Will Smith. I've talked about this case before, we focused on this case before, and now it appears the actor, as of right now, is emerging victorious from his legal fight. I say at least for now. Remember, Smith was hit with a sexual harassment and retaliation lawsuit brought against him by his former violinist on his tour, accusing the actor and his team of creating a dangerous and hostile work environment. Now, a judge has essentially thrown out all of the claims and a lot of language from the suit. But I will tell you, this isn't over just yet, because the plaintiff in this case, this violinist, Brian King Joseph, has 30 days to refile this case, meaning Will Smith's troubles may not be behind him just yet. So 30 days to come back, stronger case. What does it mean? What will he do? Look, we've got the ruling. We know what the judge actually said, so we're going to break down exactly what happened here and what we can expect. Now, if you recall, as we've talked about on previous sidebars, Brian King Joseph is a professional violinist. Apparently appeared on season 13 of America's Got Talent, made it to the top 3. Late 2024, he was hired to perform on Will Smith's Based on a True Story tour the following year. And according to the lawsuit that was filed in Los Angeles Superior Court in December of 2025, things took a turn during the Las Vegas leg of that tour, because Joseph claims that he left his bag with his room key in a crew van, and management told him they couldn't find it, and then later returned it to him. And that night, he says he goes back to his hotel room and found evidence that someone had been inside, that there was a handwritten note addressed to him that read, quote, "Brian, I'll be back no later, 5:30, just us," with a heart signed Stone F. And also in the room, apparently, according to him, wipes, a beer bottle, a red backpack, HIV medication with someone else's name, an earring, hospital discharge paperwork. And Joseph says he, quote, feared that an unknown individual will return soon to his room to engage in sexual acts with him. So he apparently reported the incident to hotel security and to Smith's tour management. He even says he called a local non-emergency police line to report this, but speaking out allegedly backfired severely for him. He says he was fired soon after this, and that the tour then hired another violinist to replace him. So Joseph filed 6 claims against Smith and his management company, including sexual harassment, retaliation for reporting harassment, wrongful termination in violation of public policy, violation of California's labor and civil rights laws. And then there were other allegations in the suit that went beyond the hotel room, because Joseph claimed that Will Smith himself had been laying the groundwork for something darker. And here is where the lawsuit tried to tie this back to Smith personally, because according to the complaint, months before this alleged hotel room incident, Smith had been pulling Joseph closer. Smith allegedly told him, quote, "You and I have such a special connection that I don't have with anyone else." The two allegedly spent time together. Smith invited Joseph to play on his tracks. Joseph believed he was being brought into Will Smith's inner circle. And the lawsuit alleged that Smith's behavior accounted to, quote, deliberately grooming and priming Mr. Joseph for further sexual exploitation, and that the sequence of events pointed to a, quote, pattern of predatory behavior rather than an isolated incident. So when Joseph apparently found this note and those items in his hotel room, he said it wasn't random. He saw it as connected to Smith. And the lawsuit alleged that someone with access to his hotel room, and he claims the only people with access were Smith's management team, left that note. And the note, combined with Smith's earlier comments about a special connection, led Joseph to believe that he was being groomed for something sexual. That's the main allegation. And by the way, we had Joseph's attorney, Jonathan Delshad, on Sidebar, on this program back in January. I asked him directly how he planned to connect the hotel room incident to Will Smith. This is what he told me.
That's the critical question in this, in tying it back, meaning, can we tie that back to Will Smith? But I think that there's a second option as well. That's just for the sexual harassment part of it. For the reporting, clearly it got back to Will Smith. I mean, that the reporting was reported to the tour manager, the right-hand man. When something just doesn't make sense, when you're like looking at typically when an employee is hired to do a job and they're doing it well, the employer is happy with that employee and they want to continue employing them. They're making money off of them. And so at a certain point, if something happens and they just for weird reasons let go of the employee, you got to look back at the employer and say, is that the real reason they're doing this? Is there something else going on here?
That was then. Now, a judge has ruled on whether the lawsuit actually stated valid legal claims. And we're going to get to that in just a moment. But Will Smith and his company, by the way, have denied everything. One of his attorneys, Alan Grodsky, issued a statement to People previously saying, Mr. Joseph's allegations concerning my client are false, baseless, and reckless. They are categorically denied, and we will use all legal means available to address these claims and to ensure that the truth is brought to light. So that is where things stood. Joseph making serious allegations, Smith denying everything, and then a judge stepped in. May 5th, Los Angeles County Superior Court Judge Michael Schultz issued this ruling. And here's what you need to know up front. The judge basically sided with Will Smith on almost everything. Every single claim that Joseph brought was thrown out. But here's why this is not, a clean knockout. Because the judge gave Joseph 30 days to amend his complaint and refile. And that is the clock we're now watching. So the ruling is quite detailed. The judge sustained what is called a demurrer. So that's a legal move where the defendant argues that even if everything the plaintiff says is true, court accepted all is true, there's still no valid legal claim. There's no case here. And the judge seemingly agreed. And he also, by the way, granted a motion to strike specific language from the complaint too. So that included the allegation that Will Smith was deliberately grooming Joseph and the claim that there was a pattern of predatory behavior. So those are strong words. That's a strong decision. And the judge said they had no relevance to the actual legal claims and called them gratuitous. But here is where it gets interesting for Joseph, because the judge didn't say that the hotel room incident didn't happen. He didn't say it's a lie. He didn't say it's a misrepresentation. No, he said, taking it all as true, just the legal pleading was insufficient. And in one key line, the judge wrote that it was, quote, not unreasonable to infer that the note, together with the other items left in plaintiff's room, reflected an intent to engage in sexual conduct. That's important because the judge acknowledged, look, a jury could reasonably see the note as sexual in nature, and that's something that Joseph's attorneys can hang on to. The problem for Joseph was everything else. The judge ruled that one incident was not enough to create a hostile work environment under California law. He wrote that the allegations didn't show a severe and pervasive pattern of harassment. Joseph reported the incident, got a new room, flew back to Los Angeles the next day, and this seemed to undercut the claim that his working conditions were unsustainable, unbearable. But it's also the idea of, if you take that incident as true, does it represent a repeated pattern? Is it such a severe incident? Like, you equate it to, I think a classic example would be if you're at your office and there's no pattern of sexual harassment, but somebody comes over and grabs you from behind. That would be so severe, even though it's an isolated incident, that it could categorize as sexual harassment. And the judge also took issue with the retaliation claim, A, because of the problems with establishing sexual harassment or a hostile work environment, but also made the claim, look, that this intrusion was at a hotel, not the workplace. But another big issue, and it was kind of a big theme throughout the course of this ruling, is the judge said there seemed to be a lack of connective tissue, that there wasn't an allegation connecting this intrusion or this intruder or intruders to Will Smith or his management team. And that is the hole in the case, because like the note that was signed Stone F, the complaint never alleged who that was or how that person was connected to Will Smith, according to the court. And without that link, the judge said there's a problem with the case. So now Joseph has 30 days to fill that hole. Can he do it? That's the question. Let's talk about it. Okay, so to answer all that, we're bringing in somebody who handles these kinds of cases every day. By the way, I think he knows this judge. Ron Zambrano is an employment attorney who represents victims of workplace discrimination, retaliation. He has settled millions of dollars in claims for employees. Ron, always good to see you. Thanks for taking the time. So first of all, you know this judge?
Yeah, so Judge Schultz, I have a case. I'm actually going to go to trial in front of him in June.
Be careful what you say. Be careful what you say.
Yeah, No, I have a lot of respect for him. And he is a no nonsense guy. He takes his job very seriously in applying the law. So once I saw his name and I could just see in my head him talking, to the plaintiff's attorney, going like, listen, well, we can get into it, but yes, I do know this judge. He's a very good judge. I'm not saying that because he's going to be presiding over my trial with County of LA soon, but I think he's a very fair judge. Yes.
Were you surprised by this ruling? And to be clear, when we talk about a demurrer like this, it's a slightly different than a complete motion to dismiss, right? So talk to me about what your reactions were to this.
So initially, again, like anything else, when I heard about this case, the allegations were so salacious. I really didn't get into. I didn't read the complaint, but when I saw that it was that there was an initial sustaining of the demurrer, which is just an attack, the judge has to assume everything in the complaint is true.
Right.
Everything in the complaint is true, and does it fit? Does it check all the legal boxes? So I was very surprised. So I looked into it. And I'm like, oh, there's nothing connecting what is gross, right? The note and what happened. But there's nothing connecting that to Will Smith. And again, the judge is being very fair. He's like, give me something. He's giving him a shot, which is very normal, right? A demur can be sustained, which is a ruling that the allegations in the complaint aren't sufficient legally. But he's going to give him a shot to amend, add more facts to try to cure this. And the curious thing is that these are such serious missing factual allegations. If they're all of a sudden there's going to be questions like, why wouldn't you say that from the beginning?
Well, that's a fair question. Why not include that in the initial pleading? Because yes, complaints don't have to include everything. They don't have to include every email or text message, but they have to be sufficient. They have to have, past that bar that it's stating a viable legal claim. And so, for example, where the judge wrote that there was no allegation connecting this intruder of the hotel room to Will Smith or his management team, the judge said the note left in plaintiff's hotel room was signed Stone F, and there's no allegation that this person is connected to the crew or cast or any other agent or employee of defendants. And he also wrote that the complaint does not allege that the intrusion was perpetrated by a contractor, employee, or by the employer. I guess my question to you is two things. One, giving now Joseph's side an opportunity to allege more facts or evidence to make that connective tissue. But B, could an argument be, well, it's upon information and belief. We are waiting to go forward with this trial. We're waiting for discovery, and then we'll have an opportunity to fully explore this and fully prove this. This is just based on circumstances right now. We're alleging the bare minimum to go forward. What do you think?
Well, you're using very usual legal language with the information and belief qualifier. But and listen, they may amend it just to keep it alive and go, upon information and belief, Will Smith or the production company is connected to this conduct, and then they can go, listen, judge, you asked for these allegations, we put them in, and they're there because no matter what, it's going to be attacked again. It's going to be attacked again with a second demur to the amended complaint. But the swing is that this will be heavily litigated because celebrities that get sued don't settle, especially if they really sense that there's weaknesses from the beginning. This is not a good start for the plaintiff. It's not like for it to be so without real connection from the beginning, because you should know from when you file this, it's going to get media attention. The person you're suing is powerful. They're going to get attorneys that are somewhat competent, and this is a very easy thing to avoid, and they didn't. Now they're here. Judge Schultz said there's not enough here. Why isn't it there in the first place? So they may try to lawyer it up and go, well, we'll make these information and belief, and so that we can maybe find it in discovery. But this is picking a fight that really should never have been brought. It should have been brought. This should have been cured from the beginning or avoided. And the risk is getting past the technical barrier, but then it's going to be a dog-eat-dog fight in discovery. It's just going to be.
One of the things that I thought was really interesting is how do you define sexual harassment? And the judge wrote here that Joseph failed to allege that this conduct was severe or pervasive enough to create essentially an abusive working environment. Again, assuming all these allegations are true, right? He specifically wrote that a sexually objectionable environment must be both objectively and subjectively offensive, and that isolated incidents, unless extremely serious, will not amount to discriminatory changes in the terms and conditions of employment. Explain that to us.
Right. So to bring a claim, any plaintiff has to allege or make the conduct fit into either pervasive or severe. It doesn't have to be both. There's this misconception, it has to be both really bad and happen all the time. It's either something that doesn't happen all the time, but it's really severe. Sexual assault, grabbing, really gross, explicit pictures and text messages. People still do that. That's how I still have a business. That's really severe, right? Objection. But here, it's not really, doesn't fit into those normal categories. So here the judge is like, listen, okay, fine. This may seem really bad and salacious. Well, not really salacious, but like it's such terrible conduct, but it's not connected to a sex or sexual act. That's problem number one. The second problem is that there is no, it's not happening over and over again, right? So something really, really bad connected to sex, explicit pictures, terrible words that I won't repeat here, or physical touching, that can happen once and make it. Or if it's something less so, for instance, you come into work, a female comes into work and the boss keeps going, I like your dress. You look really nice. I like your perfume. Those things in isolation won't make it, but over the course of a month, 2 months, 3 months, 4 months, that's a pervasive. So here it didn't fit either. And I think the judge, again, Judge Schultz, I think is being very clinical in his application of the law and going, yeah, this is a bad story. It has nothing to do with sex. It was a pervasive. So it's not enough. You need to give me, not give me, but if you want to continue with this, you need additional facts that are either severe, in maybe not in that category, but something along that category, or something that happened over and over and over again. I don't think we're going to get to, I personally don't think, based on just what was initially put in there, that we're going to get the something that's frequently happening again, and it all has to be connected to sex.
Mm-hmm. Let me talk about something that might help the plaintiff's case, because here's where it appears the judge gave Joseph something to work with. He wrote that it was not unreasonable to infer that the note, together with other items left in plaintiff's room, reflected an intent to engage in sexual conduct, opening it up to the possibility this could be something, right? It's not like you can just ignore it. I mean, if allegedly he's at not necessarily, like not in an office, but a room, it's on tour, it's in a workplace kind of environment, a little bit not. But there's at least a basis by which the plaintiff can expand upon this, right?
Yeah, there's a basis of which I like to say bones, right? That the case has good bones on which to put more meat on the bone. And the judge said there's not enough meat on the bone to hit the minimum standard of the legal elements that need to be checked off. So these things in isolation, again, all these things in isolation aren't enough. You have to plead and make your narrative in writing so that everything is connected. But then also you have to connect things to both either the production company or Will Smith as an individual. And then it has to be connected to sex. Has to be connected to sex. If it can't be like, this is really bad in the beginning about sex, and then we're going to make all these things just to talk bad about Will Smith or the company, but that doesn't have to do with it about sex. That's not enough, right? This isn't a judgment on people's character. It's a judgment on unlawful conduct. And if the unlawful conduct is only, the first paragraph, that's all the judge is going to care about.
Right. I also thought it was interesting how he struck the language of grooming and predatory behavior like this by allegedly Will Smith. He basically said that has no connection to any of the allegations that you're asserting, any of the claims. It's coming out of nowhere. Why do you think the plaintiff would include that in there?
Because it will get the press. I don't mean to be flippant, but like that language will get you media attention. It will get the attention of outlets. It's inflammatory, right? But the thing is, those allegations are conclusory. What the judge cares about, and what, if you go to a jury, what the jury will care about is, okay, I know you feel that this happened. This is the conclusion that you are coming to, but what is the thing that happened that made you make that conclusion? That's the facts that lead to that conclusion, that label, predatory behavior. That is what the judge is asking, like, where's the proof in this pudding? right? At least from your own allegations. And the judge is saying, this is basically, the judge is, this is conclusory legal language. I don't think it's even legal language. This is conclusory language that's not supported by the underlying facts. If you have support in the underlying facts, then maybe I will leave that term or that phrase in there.
So while he struck that language, the judge didn't strike Joseph's claim with the language that he feared someone would return to engage in sexual acts with him. He didn't strike the paragraphs about the note itself, at the items left in the room, which we were talking about. So if you are Joseph's attorney and you are reading this ruling, what are you going to do in the next 30 days? And by the way, just to let everybody know, we reached out to both sides for comment. So Jonathan Delshad, again, Joseph's attorney, told us he's not going to be speaking right now, said his team will put out a statement. As of the time of this recording, we haven't received that. But Delshad told us they're going to try to get back on track. We also reached out to Will Smith's team. We haven't heard back. What do you do as his legal team?
You have a call with a client, or you have a meeting with a client, and you go over what has been basically spoon-fed to you from the judges to what's deficient, and ask the client, do you have facts to meet the standard that the judge is asking us as a team to put on this complaint? And you have to find it. And if it's not there, then you have to have a different conversation with your client. But that's what you do. You have to have a sit-down conversation, preferably in person, and you go, listen, there's this ruling. This is not a mystery. The judge is not hiding the ball. We're being told what is insufficient. Now what can you tell us from your firsthand experience, not your conclusions, firsthand experience that may fit these categories that we are being told are not being met from a legal standpoint to raise a claim under the Fair Employment and Housing Act for hostile work environment based on sex.
Ron, interesting things to think about. Thank you so much for taking the time. Appreciate it.
Of course.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, 11 p.m. Eastern, Monday through Friday. I'll see you next time, everybody.